The EU has had many successes since its creation, but perhaps one of the most important is the establishment of a single European market. The existence of a unified market, however, requires that member states refrain from granting selective support to companies in their jurisdiction if that could distort competition and trade. This has led to the development of a distinctly European regime known as state aid. In this video, we will look at how the state aid rules developed and how they are enforced today. Subsidy control features in almost all free trade systems in some shape or form, and while the EU state aid rules are unique, a common theme with other international subsidy control rules, such as those of the WTO, is the protection against trade distortion by way of government intervention. That is because subsidies can act as barriers to efficient trade by giving an artificial advantage to their recipient to the detriment of the competing industries in another country. By way of example, let us imagine two newly joined EU member states. One has a successful wool industry, sheepland. The other is sheepland's closest trading partner, beefland, a less efficient wool producer that focuses on beef products. Beefland, in an attempt to improve its own wool industry, starts offering financial assistance to wool producers by paying them subsidies to cover certain production costs. Beefland's wool industry can now compete strongly with sheepland's by selling at lower prices. Beefland has artificially improved its wool producers' trading position, eroding the trading advantage enjoyed by wool producers in sheepland. Beefland can now export wool to other member states as well, which can further worsen sheepland's trading position in the wool market in the EU. In order to protect its own industry, sheepland now begins subsidizing its own producers to offset the effects of beefland's subsidies, leading to a subsidy war between the two countries. This causes inefficient government spending and leads to both countries being worse off. This same logic can be applied to trade in the EU between member states, where the interests of 27 different nations must be aligned, each with their own strong and weak domestic industries. State aid rules act as a barrier against such trade distortions. Turning to the rules, Article 1071 of the TFEU prohibits state aid from being awarded, unless it is found to be compatible with the internal market. The same provision defines state aid as aid granted by a member state or through state resources in any form whatsoever, which distorts or threatens to distort competition by favoring certain undertakings or the production of certain goods, insofar as it affects trade between member states. Therefore, not every type of government intervention is considered state aid. To be considered as such, all the conditions of the definition must be met. First off, there must be some sort of state intervention that involves state resources. State intervention can take various forms, such as grants, loans or guarantees, tax relief, or providing goods or services on preferential terms. What constitutes state resources has also been defined broadly and can take the form of both positive contributions from state funds as well as the foregoing of revenue, such as by not collecting taxes. Let us recall our example. Beefland paid wool producers grants to cover their costs. This constitutes a state intervention involving state resources. By contrast, if, for instance, Beefland obliged all its clothes producers to use at least 50% wool due to a public policy objective, whilst this could benefit wool producers, this type of measure would not constitute state aid, as no transfer of state resources is involved. Secondly, the aid must be granted to entities or undertakings that provide goods or services in a market. In other words, subsidies granted directly to consumers will generally not constitute state aid. For example, if Beefland decided to boost its domestic spending by granting €50 to each inhabitant, that could potentially benefit all of its industries, and one would not call foul play. However, these types of measures should not indirectly favor certain undertakings, as that would still constitute state aid. Had Beefland granted €50 to each inhabitant on the condition that it could only be spent on domestic wool products, this would indirectly favor undertakings in Beefland's wool industry. Thirdly, the measure must grant the undertakings in question an economic advantage outside normal market conditions. This means that any state intervention on market terms where the state acts as a normal market economy operator, would not normally breach state aid rules. This is known as the MEO principle, or MEOP for short. For example, offering a public loan at market interest rates would not amount to state aid. Applying this principle to the example we gave earlier, beef land subsidies granted an economic advantage outside normal market conditions, as the payments effectively alleviated costs that its wool producers would otherwise have had to incur. This is because a market economy operator would not enter into such a transaction without aiming for a profitable return. Fourthly, the measure must also be selective. In practice, this means that the measure must favor certain undertakings in law or fact. On the other hand, measures of general application capturing all undertakings and sectors will not amount to state aid. If, for example, beef land were to offer a general tax break to all the undertakings operating in its jurisdiction, whilst this would benefit wool producers, it would not constitute state aid. By contrast, in our example, beef land subsidy targeted a specific industry and by extension favored certain undertakings selectively. Finally, a measure will only constitute state aid where it distorts competition and affects trade between member states. But in practice, these two limbs are usually satisfied if the other conditions are met. Before implementing a measure that constitutes state aid, a member state must notify its intention to grant the aid to the European Commission pursuant to Article 1083 of the treaty. Once notified, the member state must await the Commission's decision on whether the measure is compatible with the internal market. This is known as the standstill obligation. In this respect, EU law recognizes that in some circumstances, government intervention is necessary for a well-functioning economy. It therefore leaves room for a number of policy objectives listed in Articles 1072 and 1073 of the treaty, under which state aid can be considered compatible with the internal market. These objectives include the development of certain economic activities, promoting sustainable development, or remedying a serious disturbance in the economy of the member state concerned. The Commission has also developed secondary regulations that streamline the award of state aid in some sectors through block exemptions, rules on de minimis aid, and rules on services of general economic interest. Where a member state breaches the standstill obligation and grants aid without the Commission's prior approval, this aid will automatically be unlawful until the Commission has reached its decision on compatibility with the internal market. During this period of unlawfulness, interested parties, such as competitors of the beneficiaries of the state aid, may bring a claim before the national court of the member state concerned to seek the recovery of that measure. In parallel, if the Commission ultimately finds the measure to be incompatible with the internal market, it will also order the recovery of the measure if it has not already been recovered. A recovery decision will look to undo the distortions in trade and competition caused in the market concerned by the incompatible aid. Whilst a recovery obligation is not, strictly speaking, a fine, it can sometimes have far-reaching effects, such as requiring parent companies that have acquired the aided company to pay back the aid along with interest on such payments. The rules on state aid form one of the fundamental pillars of EU competition law. While state aid can have malignant effects when granted without proper consideration for trade and competition, it can also be used as a tool for innovation, as well as remediation. To ensure that member states can only award state aid that is beneficial for the EU, the European Commission is granted strong investigative and decision-making powers. The result is that state aid control and the EU go hand in hand.